Welcome to the State Archives of North Carolina's tutorial on public records and confidentiality for local governments in North Carolina, Part 2. During Part 1, we discussed public records law and the difference between confidential information and confidential records. Now we will look at two more examples and see the difference between confidential records that can be released and those that cannot. Public enterprise billing information is another category of information that North Carolina state law declares is confidential and not automatically open to the public. Public enterprises include water, wastewater, solid waste, parking facilities, and other such systems. Public enterprise billing information is any record or information within these enterprises concerning individual customers. Since the law declares that public enterprise billing information is, quote, not a public record, what does this mean for confidentiality? Not a public record means only that the public does not have automatic access to it. You may still release that information under conditions listed by law. First, in connection with bond financing. Second, to maintain the integrity and quality of enterprise services. And third, to assist public safety. If you are going to release this information, you should do so according to these conditions, and you should release it consistently. For example, placing utility bills on postcards will make enterprise services more efficient. Every account holder's information is released this way, so this would be a legitimate release of information. An example of an illegitimate release would be disclosing the water bill of a candidate for public office to someone who requested to see it. This brings up an important distinction in public records law and confidentiality. Some confidential information, not automatically open to the public, may still be released at government agencies' discretion. Other information may not be released at all. Information that may be released includes confidential legal communications, public enterprise billing information, criminal investigation and intelligence information, public security information, and other information on this list. The statutes often list the conditions by which the records may be released, but not always. Follow the law, use your best judgment, be consistent throughout your agency, and, when in doubt, contact your local records analyst. By contrast, local tax records showing income or gross receipts, trade secrets, electronic payment account numbers, personal identifying information, personnel files, and medical information may not be released to the general public. Release of this information, whether accidental or deliberate, can have negative consequences. For example, information about a taxpayer's income or receipts may only be disclosed, first, to comply with a court order or law, second, to be reviewed by the Attorney General, third, to administer the tax itself, and fourth, to include property tax information on a property tax receipt. Records containing this information are not open to the public, but may still be released as long as this information has been redacted. Contact your analyst if you have any questions about whether you should disclose these records or not. What happens if taxpayer income information is released? The person who released it may be found guilty of a Class 1 misdemeanor and may be dismissed from public employment. Records that may not be released often have penalties attached to their disclosure. Public utilities billing information and taxpayer income information are not the only categories of records and information made confidential by state or federal law. Other confidential records include personal identifying information, public security records, attorney-client communications, criminal investigation records, economic development records, minutes of closed sessions, medical information, education records, and information about juveniles. When in doubt whether a record is confidential or not, please contact your analyst at the State Archives of North Carolina. In summary, confidentiality can be incredibly complicated, depending on the record or the information involved. The main things to remember are, first, in order for a record to be confidential in North Carolina, there must be a specific state or federal statute making it confidential. Second, some confidential records cannot be released, and others do not have to be released. Third, in order to learn which is which, you should check the statutes. Fourth, you should check with an analyst if you aren't sure whether a record is confidential or not. If your agency frequently handles matters of confidentiality, or if you would like further resources, there are some excellent publications that deal specifically with confidential records laws in North Carolina. David Lawrence's book, Public Records Law for North Carolina Local Governments, examines state and federal laws regarding public records, including laws regarding confidentiality, in great detail. Laws Relating to Confidential Records Held by North Carolina Government is an additional publication that can be found on the Government Records Branch website by clicking on the Guidelines link. This is the contact information for the local records management analysts at the State Archives of North Carolina. Our job is to assist local governments in applying public records law and good records management principles to their records and their work. This is especially important in matters of confidentiality and public records requests. Whenever you have any questions about public records management in North Carolina, please contact one of us and we will be happy to help. Thank you for watching this tutorial.